I'm going to announce or ask that the parties make the appropriate announcement when they hear the case call. Position number one is SLM Private Credit versus Thomas Ward. I'm showing an attorney listed as Ralph Breeden for.
That's me, Your Honor. I don't have Thomas Ward on my calendar. I apologize. Let me see if it's.
It looks like from my review of the notes on the case that there was an answer that was filed late. So my presumption is that you're here to seek a default judgment.
That would sound accurate. Do you have the case number on that, Your Honor?
Yes, sir. It's 2017 CM 20232.
And who did you say the plaintiff was on that?
Thomas Word.
And I'm sorry, who was the plaintiff again?
SLM Private Credit.
So I apologize we didn't get that, Your Honor. That's Navient, and they have put a hold on obtaining a judgment in any case.
Okay, so you're asking for it to be dismissed?
Yes, Your Honor.
Okay. It'll be dismissed at plaintiff's request. I need you to send over a dismissal to Miss Mary, and I'll put my my John Hancock on it.
I will do so.
Okay. Position number two is LVNV Funding LLC versus Dwight Miller. The case number is 2019 CM 29380.
And Your Honor, that is that one is mine as well, Your Honor.
Okay.
My understanding is we received a request from the court for an order. We submitted a affidavit of default and consent judgment. We sent an email with it on Friday, and I tried to e-file one this morning, although it does not appear to have been accepted yet.
With the proposed order?
I apologize.
With the proposed order?
Yes, Your Honor.
Okay. And I see someone is saying Dwight's phone.
I'm here. You need to see me, sir?
Mr. Miller, I need you to turn your camera on.
Okay, give me 1 second. How you doing?
I'm doing well. I see that there was this case was placed on the bench trial calendar for December 17th, 2019, and there was a rule nisi issued on it November 18th, 2021 for this case to be placed on the calendar. And it appears
I'm not
to
sure
be,
what's really going on.
hold on, sir. It appears to be on a bench, I'm sorry, default judgment calendar. Did you appear in court on December 17th of 2019?
Yeah, I went to court, and it was for the matter of that, but it was for a different amount. And when I had spoke with the lady, I told her I still didn't know what it was. But when we did the pre-trial, she just told me to basically sign, and that I can come back and go over the case with him and see what it is that we need to do, because I told her I didn't know what it was. But after that, I never heard nothing. And then I got a judgment paper. And then when I got a judgment paper, I was told to that I had to pay this outrageous amount that I didn't even have on the card. And then I figured out that they sold my information to the original debtor, sold my information without me even knowing. So I still was unaware of everything that was going on. And so that's what I'm trying to get a grasp of now.
Which those are lawful things that can take place. And once a judgment is entered, there's post-judgment interest that starts to accrue.
Yes, sir.
So what I'm going to do is I'm going to mark this to have a hearing, and I'm going to hear from Mr. Breeden, and I'm going to hear from you as to the appropriate amount. But you have to understand, post-judgment interest is lawful.
Okay.
So
But
you can get a, so for example, you get a judgment against you for $100 today. And if you don't pay that judgment until 6 years from now, there's post-judgment interest that accrues so that the plaintiff can request that amount also. Okay. So the $100 may have moved off to a higher number just because it wasn't paid off.
Okay. So so this is my thing though, but I guess this thing we'll speak to in the hearing. But my thing was, they came immediately that day and said I owed a $2,000 balance, I believe, and there's no way possible for me to owe that on a card that didn't even have a $300 limit. I paid the card off before I closed the account. You get what I'm saying? And so that's why I was trying to figure out where the disconnect was with that. And nobody ever gave me an explanation, but it was just I keep owing money and then constant judgments because nobody's communicated anything. And it's a lot of, oh, well, we sent this or we tried doing this, and I never received any of it.
Mr. Breeden, do you have any other cases on this calendar?
No, Your Honor. And we're not seeking post-judgment interests on this.
Okay.
And I'm not sure if he's thinking of the correct case because his answer marked, I request a payment schedule.
I was gonna.
I told you. Hold
on, Mr. Miller, hold on.
I got you.
Based upon the announcements that I was hearing, I was gonna place the two of you in a breakout room to have a discussion, but I wanted to make certain that Mr. Breeden didn't have any other case, or that you didn't have any other case on this calendar, because if this is just a situation of there needs to be a meeting of the minds, then that happens through conversation. So I can place the two of you in a breakout room and you can make your pitch to Mr. Breeden and he'll listen, because Mr. Breeden is also on an obligation. He can't claim monies that are not lawfully owed. So, and he's an attorney. He has way more to lose by trying to get an extra $500 out of you than anybody else. So if you just explain your situation to Mr. Breeden, he will make the judgment. And if you don't agree, you don't agree. And we'll end up speaking about it. Is that fair, Mr. Breeden?
I'll be happy to speak with him, Your Honor.
Okay, I'm going to place you in breakout room number number 1.
Okay.
And I'm going to allow the two of you to have discussion, because hopefully we can move this along so that we're not just having this conversation in open. So Mr. Miller, you're going to get a link notification for you to be able to link into the breakout room, and it'll just be you and Mr. Breeden having a private conversation. Okay.
All right, thank you.
You're welcome. All right, position number 3 is Jennifer Alwine, Ralph Alwine versus JH Plastering and Handyman Service.
Good afternoon, Your Honor. Elizabeth Rose. I represent the plaintiffs, Jennifer and Ralph Alwine. Based on your earlier announcements, I would propose that we submit a proposed order granting the motion for default judgment. This is a case where it was filed back in April of 2020, and after the expiration of the state emergency orders, the defendant was duly served and still did not answer. We served him or served the company with our motion for default judgment. Haven't heard anything, and I guess I should leave it to you, but don't see anybody here appearing for the defendant, and the amount was liquidated in our statement of claim.
And I don't see an announcement from JH Plastering and Handyman. So if you would send the proposed order to Miss Mary, I will sign off on it.
Thank you very much. May I be excused?
Yes, ma'am. Have a good day.
Thank you. You as well.
Okay, position number 4 is Spivey Club Homeowners Association versus Tashina Hamilton and Omni Day Spa. And this appears to be a continuing
Gardner
garnishment.
here.
How are you doing, Mr. Gardner?
Good.
Gardner.
Yes, good, Judge Gardner. Good to see you. Gardner. It looks like Gardner, but Gardner is right.
Okay. So
Right.
we may be related somewhere down the line.
I bet we are.
This is a continuing garnishment and looks like a request for default judgment was filed on May 14th of 2021.
That's correct, Judge. And it looks like Miss Hamilton is here. The defendant, of course, in the continuing garnishment. I believe what we're on the calendar for is on the default. I don't think we have a traverse. I haven't seen what was actually filed with the court. I think she's sort of improperly entering an answer on behalf of the garnishee, which she claims to be a family entity that she's not involved with. With the garnishee not filing an answer, we would ask for a judgment against the garnishee because we'd like to see them file that answer themselves and explain to us how this person is not involved with the company.
Miss
Yeah,
Hamilton.
so how can I, this is Tashina Hamilton.
Hold
I'm sorry.
on.
go
Miss
ahead.
Hamilton, first of all, turn your camera on.
Okay,
I'm gonna give you every opportunity to speak, so you don't have to rush through this. I have a quick mind, but I have slow ears. So
Okay.
The position that I hear from Mr. Gardner is that there was not an appropriate answer filed on behalf of the garnishee, which is Omni Day Spa. What is your response to that?
so Omni Day Spa is my baby sister's new spa, and I'm not sure. I don't believe that she understood that she needed a response because I never worked there. So she's like, oh, she's never worked here. So, and I did communicate that with Dunlap and Gardner. I believe it was back in October or November, that information was erroneous, that she should not have, or the spa should not have been listed as a previous employer in the first place, because I never worked there.
So the way that it generally works, that's all she had to do was file an answer to say you never worked there. But if Mr. Gardner has notified that company that he intends to seek garnishment of wages, they just can't not respond.
Mm-hmm. Well, and since, and I don't know if Mr. Gardner, if you're on the communications with Wes Dunlap and I, and Chastity, I believe. But I have began, outside of Omni Day Spa, I have began making arrangements and payments on the debt that's owed. So I don't know if we can start here to exclude Omni Day Spa from this in its entirety and just continue with the arrangements that I have with Dunlap and Gardner. And
Mr. Gardner, would you want to enter into a breakout room with Ms. Hamilton and see if there's an agreement that
Sure.
can be worked out? Okay.
Sure, I'm happy to, Judge.
I'm going to place the two of you in breakout room number 2. And what I am looking for is an agreement that encompasses whatever the amount is owed. And if it's to Mr. Gardner's satisfaction, I can dismiss the case against Omni Spa, or I can continue this as it relates to an agreement entered into as to payments that are made. Because, and as Mr. Gardner knows, the bottom line with all of this is just money, and about making certain that any debt that is owed is paid. And so I'm willing to work with both sides. I'm not going to force Mr. Gardner to file a new action and expend additional monies. But if there's an agreement that can be reached, I can continue this case so that the agreement is honored. And if it's not honored, there can be terms in the agreement that the payment is accelerated. So that, for example, if there's an agreement as to how much is owed for each month, and then there's a payment that's missed, I'm willing to sign off on agreement that will make the entire amount owed at that point. And so the plaintiff can be reasonably secure that they're going to be able to recover whatever monies is owed. And the accused is in a position where it's not all placed on you at one time. And so there can be accommodations reached on both sides so that whatever debt that's owed is paid and both sides walk away.
yes, and that's what we began to, thank you so much for that. That's what we began to discuss and we arranged back in November and December. So I think it's just a matter of us just catching up in the breakout room and, discussing it. That'll work for me.
Okay, so I'm going to place the two of you in breakout room number 2 so that you can discuss possible ways to resolve this matter.
And how do I get to the breakout room? I'm sorry.
Okay, so I tell everybody I went to law school. I didn't go to Georgia Tech. My understanding is that once I place you in the breakout room, you will get a link that you can click on that will place you in the room. So I've just placed you, Ms. Hamilton, in breakout room number 2. And Mr. Gardner, I'm going to place you in breakout room number 2.
Thank you, Judge.
Okay, thank you. All right, position number 5 is Tara Wrecker versus a Harley Davidson motorcycle versus a James McDonald. Who's here on behalf of Tara Wrecker? I don't hear an announcement. Is there anyone here on behalf of the Harley Davidson motorcycle? And finally, is Mr. James McDonald present? Okay, Miss Mary, this case is going to be dismissed for warrant of prosecution. It's
Okay.
position number 5. Position number 6 is Mission Financial Services versus says AKA Cedric Jones.
Jim Nealons for Mission Financial, Your Honor. It should read Cedric Jones. AKA Cedirc Jones. Evidently, there was a typo somewhere along the line where we misspelled his first name.
Okay. So is this true and correct, true and correct name Cedric Jones?
That's correct, Your Honor.
Okay. And this is on a request for default judgment that was filed on September 17th of 2021. So what I am going to request of you, sir, is to send a proposed order to my judicial assistant for the amount that you believe is owed in this matter.
So an order requesting you to grant default judgment for that amount?
Yes, sir.
Okay.
And you're entitled to court costs also.
Okay, great. I sent over, I was mistaken. I thought the exhibits had been sent quite a while ago, and it came to my attention that it didn't look like they had been at all. I emailed those exhibits just this morning to Magistrate Court hearings at ClaytonCountyGA.gov. Did you receive them?
I did not, but if you resend that email along with the proposed order to Miss Mary, that'll satisfy what I need.
Of course.
Okay. So, sir, you can be excused if there's nothing else.
That should do it. Thanks, Your Honor.
You're welcome. Okay, we resolve position 7, position 8, Gwinnett Locks and Keys. Andres Moriano versus F&L Auto Paint Supply.
Good morning, Judge. Paul Panuski on behalf of Gwinnett Locks and Keys.
Okay, how are you doing, sir?
Good, and you?
I'm doing well. Looks like there was a request for a default judgment filed on October 28th of 2021.
That's correct, Judge. And I didn't see any filings by Mr. Garcia at all.
Okay, Mr. Garcia,
Bueno.
you're buffering. You're
escucha, Honor?
buffering poorly. Okay, Mr. Garcia, you're buffering poorly.
Is there any way you can use this phone?
I did not understand anything that you said, Mr. Garcia. Can you find a location where you have either better sales?
Judge, if I may.
Yes, sir.
Wow. Is it, Mr. Garcia, could you stop talking for a second?
I just muted
Yeah, put
him.
it on mute. Is it possible maybe Mr. Garcia can call in on his phone, keep his camera up so we'd have a clear audio and a visual?
That's fine by me, Mr. Panuski. Do you believe it will be?
I honestly don't, Judge. I don't know. I'm not sure why we're here.
Okay. It looks like this is there is a request for default judgment filed. Has an order been signed?
No, Judge, it's in there as well.
Okay. What I'm gonna need you to do is send it to Miss Mary.
Okay.
And the reason I'm asking everybody to send it to Miss Mary is because there are a bunch of tentacles and stuff gets socked away somewhere, and you may call the clerk's office saying that you're waiting on an order, and I don't even know that
Understand.
an order is there. So I'm trying to streamline that process. So if you call and there's a question about an order, I have one person that I speak to almost every day that we can resolve it, rather than I've had conversations with people in the clerk's office and they're saying, well, they sent an order and it was an application for condemnation of funds. And I requested an order. But the person in the clerk's office is saying, well, oh, we got your order. We're just waiting on the judge to sign it.
Yeah.
So I'm streamlining that down. So I'm not in this position.
I understand, Judge. So is that, I have the same order. You want me to just send that to Miss Mary? And it does look like Mr. Garcia's picture is cleared up.
Yes, Mr. Garcia, unmute yourself, sir. Mr. Garcia, I need you to unmute yourself.
Button next to that.
Yeah. You know, I've suggested that it'll make a good comedy sketch show of Zoom court hearings.
Zoom court hearings.
Where I can't tell you how many times I say, unmute yourself. I can't hear you. Okay.
It has its benefits and its drawbacks.
Yes.
He is calling in, Judge.
¿Me escucha, Honor?
Okay.
¿Me escucha?
Yes, I can hear you now.
Okay. I'm sorry, Honor, but my English is not that good, and I have my son next to me that he can translate for me.
Okay. So, Mr. Garcia, we have a motion on the table for a request for a default judgment. And I didn't see when I went through the records that there was any responsive paperwork signed or filed on your behalf.
We tried to respond. Dile que tratamos de responder y que incluso tratamos de llevar los documentos, pero que teníamos que esperar hasta el día de la corte para presentarlos, las evidencias.
He said he tried to send it and he tried to deliver it, but they told him to wait for the day of the court in order to present evidence for the case.
So it looks as though there's a civil suit filed on August 6th of 2021, and there was no answer filed. You generally have 30 days to respond to the filing of a lawsuit. And if you don't file a responsive pleading, then the plaintiff is in a permission to ask for a default judgment. And there are legal ways that a person can try to get themselves out of default and back on the court's calendar, but it looks like those steps were not taken in this case.
Is there any way to do that? Because he tried to, and he couldn't get, they told him to wait until the day of the court.
Judge, if I may.
Yes, sir.
So this case was filed, as Your Honor said, in the beginning of August, or I think it was August 6th. The sheriff had personally served the defendant on August 24th and we have that copy. But Your Honor, my client waited far longer than the 30 days. My client sent the letter in April and he waited until August to file a response. Mr. Garcia made no attempt to contact my client. I reached out several times to contact Mr. Garcia. This was over Mr. Garcia giving my client a check and then turning around and canceling the check after my client had left. And then there was some interaction between them where he continued to say he wasn't going to pay. At this point, my client has waited quite a long time, and I'm not sure who Mr. Garcia is talking about that said wait to file an answer. I can't imagine who that would be.
Well, I mean, and I honestly, Mr. Garcia, at this stage, the only issue on the table is the amount of damages.
Señor Honor, le puedes decir que cuando vinieron los sheriffs, él se llevó la llave, él pidió la llave del carro y tuve yo que pagarle a este señor para que él hiciera la reproducción del carro.
Okay. He said when the sheriff came, the sheriff told him to give back, and when he gave back the key, that he had to hire someone else to come and to do the service that the other man did not provide. That's when he took the check. Well, that's when check was taken away.
And so, just so you know, those will be issues that will be ripe for a trial, for the court to weigh the evidence and make those determinations. If a person sits on their rights, you can do that, but there are consequences to that. And so I can't take in evidence about whether there's a debt owed or not at this point.
Pero dile, el servicio que él produjo nunca fue funcionable y que él me dijo que a él no le importaba el servicio, que ya tenía el cheque. Él nunca me mostró que ya había hecho el trabajo.
When he came and said that he was finished, he never provided, like, he never explained to him that the service was actually complete. He just said that, here's the key, I have the check, thank you, I'm gonna leave now. And he never showed him that the car turned on or anything was functioning correctly.
Again, those would be matters that would be ripe for a trial. But if I receive notice that someone is suing me, my only response is to file an answer. If I choose not to do that, the person that filed the lawsuit is perfectly within their rights to go request a judge to sign an order for a default judgment. So we're at that stage where it's not whether you owe anything, it's how much do you owe. We're at that stage. We move past whether there's an obligation to pay or not.
Ahora tiene que pagar.
Pero dile que por $213 yo no tenía problema. El problema es que si no hay un servicio y si no había nada, él fue directamente para promover las evidencias y que a él lo regresaron. Do you remember that I told you they go and provide that? So
Yeah.
that you can tell the judge that? And what did they say? ¿Qué te dijo?
They said the key, the problem was the key would not operate the vehicle.
Judge, I mean, we're still trying.
And Mr. Panuski,
Thank you.
I got it. I
I-
got
I-
it. I
sorry.
got it under
Thank you.
control. So what's going to happen next is that Mr. Panuski is going to present a proposed order for the amount of damages that he believes his client is owed. Your best bet is to enter into some kind of agreement with Mr. Panuski as how that's going to get paid. The fact that you didn't respond to the lawsuit after you got served, that is out of my control. I'm a judge and I'm required to follow the law. I'm not here to play favorites for anybody. My job is to follow the law. And if it means that person may get disadvantaged, well, that happens. But I can't, if I were to do anything different, then I would be putting Mr. Panuski and his client at a disadvantage because you didn't do something that you were legally obligated to do.
Is he able to, well, I know at this point you don't, he can't, I get right case, but can he do that at a late, let's say if he wants to at a later date with a different judge and like take it to court if he can? Is there a possibility to do that?
Well, there's going to be an order that's presented to me that I'm going to sign. And if Mr. Garcia wants to appeal, he can appeal, but he's going to have to pay the entire amount that's owed into the registry of the court to
Okay.
appeal my judgment.
Si podemos arreglar ahorita cuánto necesita. ¿No podemos?
Bueno, él ahorita, el señor que está para el otro,
Ajá.
le va a dar sugerencias y usted puede hablar con él qué puede pagar cuánto.
A ver.
He said,
And even though he's able to do that, he could be in a situation where he ends up paying a lot more money than if he had just accepted the fact that he didn't file an answer and
Yeah.
now this amount is owed.
he said he's willing to pay the amount,
O no,
Okay.
but depending on,
depende how much.
try, talk with him and settle an agreement.
Do you have Mr. Panuski's number?
No,
No, sir. No, owner.
Okay. Mr. Panuski, what's your business number?
It's 770
okay.
373 7268.
Yeah, I can give it to you, my phone number.
I would call Mr. Panuski because I'm always careful about not putting people's personal information out. So you can call his business number and identify yourself, and I'm certain that he will get the message and speak to you.
Okay.
But this is on YouTube, and so you don't know what kind of crazy people may be out there, and if they get your personal number, you may be getting phone calls from people who are just wackos. So
Tiene que hablar con él.
Okay.
Okay.
Okay, owner. Yo hablo con él. Dile.
He'll call him.
Mr. Panuski, send an order over reflecting what I said, and if you get payment,
Judge, if I may.
yes, sir.
I'm speaking to my clients, and my clients have been flexible and patient. I'm willing to talk to Mr. Garcia this week. And if we can if we can come to an agreement, I can send over an order that matches that agreement to what I think would be maybe faster payment of maybe a slightly discounted amount, because obviously my clients want their money. But if we don't come to an agreement, or if he doesn't make the payment as proposed, it'll be the full amount. And I think we should be able to do that. But if we can't come to an agreement, I'll send over the order as is.
Mr. Panuski, I'll give you until Friday
Thank you.
to make that happen, and include a clause in there that if there's a payment plan that is set up, that non-payment at any amount will accelerate the issue so that all monies are owed immediately.
Thank you, Judge.
Okay. Is there anything else, Mr. Panuski?
Nope, not from us.
So I
Okay.
should expect something from Mr. Panuski by Friday, can we say 3:00?
That should be fine. Thank you, Miss Mary.
Thank you.
That way it gives us time to process it before the end of the day, Miss. Okay.
All right. Because I
Thank you,
got,
Judge.
you're welcome. You're free to
Maybe-
go.
Thank you.
Mr. Panuski and Mr. Garcia, you're free to go. Please stay in contact with Mr. Panuski to try to work out an agreement. I'm happy to sign off on whatever agreement is reached by the parties.
Thank you, Judge.
Okay, thank you.
Bye-bye.
Okay.
Okay, position number 9 is Latonya Edwards versus King Automotive LLC.
Yes, I'm here.
And we're here on a request for default judgment that was filed on October 20th, 2021. And my notation shows that there is a late answer filed on December 22nd, 2021. And are you, Mr. Cousins, are you here on behalf of King Automotive?
No, I'm
Okay, I see you, King Automotive.
no.
Okay, I'm sorry, Mr. Cousins. Ma'am, were there costs paid to open the default? From King Auto, the representative from King Automotive.
I'm sorry.
Excuse me, I'm sorry.
Were there costs paid to open the default? Because there's a very strict procedure that
Right.
has to be followed. Was that procedure followed?
Yes, it was.
Miss Edwards, were there costs paid to open this default?
There was.
So you should be on a trial calendar, not a motions calendar. What's the motion that we're here to hear?
I'm not really sure.
I was wondering the same thing.
Okay.
I will say I requested a default judgment after I filed the suit and I wasn't able to get any resolution. I tried to talk to King Taylor, who was the owner of the shop. I wasn't able to get any resolution. He didn't answer anything. I talked to him again in December, and then that's when they filed a late answer.
Okay. Miss Mayor, what's our next available bench trial?
Hold on, let me check, okay? Judge,
Yes, ma'am.
okay. If you wanted to put them on your bench trial, we could do it tomorrow. Otherwise, the next one is the 22nd of February.
Are you two ladies available for tomorrow at 8:30?
Yes, I am.
I'm not.
Okay.
You said are now?
Miss King from King Automotive is not.
What about
Okay.
1:30?
I'm not available tomorrow at all.
Okay. So what was the next date after that, Miss Mary?
The 22nd. I think it's only her 8:30 calendar. Hold on, let me just double check.
That's Judge George.
Yes.
Okay, ladies, I'm gonna have this case placed on the calendar for February 22nd. The best outcome in these cases is a negotiated settlement, as both sides feel that they're right and a judge can't split the baby. Judge is going to rule for one side or the other. So somebody's going to walk out of there unhappy. And if that's what you want, that's what you get. But I just make that admonition because everybody believes they're right until they place their lives in a third party's hands. I don't know either one of you. The dispute you have is a dispute. And if you choose to go to trial, then somebody's going to win, somebody's going to lose.
Yeah, I've tried to work. They've had my car since March of 2021. I've tried to contact the repair shop several times. I've been lied to repeatedly. So it doesn't appear that they want to work anything out. So that's why I filed the lawsuit to begin with.
Well, we've offered to work things out with you in December. I believe King did come to an agreement with you.
He didn't come to an agreement with me.
Hold on, ladies.
No, we didn't come to an agreement in December.
Hold on. So we're getting into what a trial will be about, okay? If there are misunderstandings, if there's something along the way, those matters can be resolved. But if we're talking about a vehicle that is in King Automotive's possession, and there's been a request to return the vehicle, and King Automotive is not returning the vehicle and haven't taken steps to have the vehicle deemed as an abandoned motor vehicle.
That's our next step, actually, to be honest with you.
Well,
that's why I requested the court calendar, because they didn't repair the car for months, and then the car was damaged while it was on their property. It was in December that he told me he had just repaired the car. I asked for their insurance information to file a claim. They told me they didn't even have insurance. And then they added $500 to the cost when I asked for the insurance information.
So again, I'm not going to get into the facts of the case at this point, but just from the limited amount that I've heard, there may be some compelling arguments on both sides. And the only thing the court can do is fashion a remedy that is lawful. So if there's been a demand made to return the vehicle and that demand hasn't been met, and there are issues about whether the car was repaired or anything like that, people just get themselves down a road that they don't want to go down just because they don't want to see the other side's position. And from just a little I heard, there may be some criminal liability that's out there. So resolution of disputes is always better. And I'm just letting you know.
I've tried to resolve it. And I
So
don't know what else to
Miss
do.
Mary, what's the next trial calendar that we have for this case?
Do you want me to look past Judge George's calendar date of 22nd at 8:30?
Yes, and Miss King, you know, generally subpoenas say lay all your business aside to come to court. What is it that you have going on that you can't appear in court tomorrow
Well,
to
I have
have this
other
matter
obligations.
finally resolved?
I would love to attend tomorrow, but my daughter is actually performing at the Hawks game, and I have opted to do makeup and hair. Unfortunately, that doesn't sound legitimate to you guys, but I won't even be here at the shop. I've already obligated to do that for them there.
So the Hawks game is at what time?
I think it's at 6, but I have to be there at their school at, I believe, 9 o'clock to get them ready.
In the morning?
Because it's about 14 girls and I have to do hair and makeup.
Ma'am, I may, if this dispute is so important to you that you can't lay your business aside to deal with it.
Well, with us being here, seems kind of pointless, not to be rude, but I believe we should have already been on the calendar for, I guess, court proceedings.
Well, I'm taking your word for it that you did what you needed to do to reopen the proceedings. But if I check into it and look for receipt numbers, because I didn't see anything about receipt numbers in the case file, which told me that the costs were not paid to reopen the case. So if that's the case, you're not going to be back in court. You're going to be receiving a judgment.
Okay.
So I can't be any more. I mean, we have too much stuff to deal with.
Let me look into it right now. Let me look at this right now.
Okay, I'm gonna place you two back, and I'm gonna let Miss Mary look into where the costs were paid, Because if costs were not paid to reopen the default in the manner that's prescribed by law, we're going to deal with this as a default judgment.
Okay.
Okay. Mr. Breeden. Oh, well,
Yes,
hold on,
sir.
hold on. I'm sorry, Mr. Breeden. Well, I'm gonna give you the respect that you deserve. Do you have an announcement as it relates to position 2?
Yes, Your Honor. So we are going to withdraw our request, our affidavit of default and consent judgment. And we're instituting a new agreement with Mr. Miller.
Okay, I'm gonna give you until Friday to draft that agreement, either sign express permission by Mr. Miller or sign with Mr. Miller's consent. Probably I'll accept either because I know with COVID times and things like that, but at least he has an opportunity to review the agreement. And then you email it to Miss Mary and I'll sign off on it and this matter will be done.
Okay, I can do that, Your Honor.
Okay, Mr. Miller, do you understand what the court is requesting?
Tom, we're gonna work it out.
Okay. All right, stay in contact with Mr. Breeden and please be responsive to him so that we can get this matter resolved.
No problem.
Mr. Breeden, is there anything else you have before me today?
No, Your Honor, maybe may I be excused?
Yes, sir. Mr. Miller, you can be excused also.
Thank you.
So, Mr. Cousins,
Yes, Your Honor.
we are here. Tara Rucker versus Freightliner. Is it Cascadia?
No, they have a bunch of the information incorrect. It's a Freightliner Columbia, not a. I have a Cascadia, but that's a brand new truck.
Okay. And this is abandoned motor vehicle. There is an answer filed, timely answer filed on January 26th of 2022. And there is a court notice sent. With Tar Record not being present, has there been an agreement reached?
This is the bottom line, Judge. My truck was at Marmark's repair shop. It wasn't abandoned. I gave the guy money to rebuild my motor, but I bought a new truck. And this is a guy I've known for years. However, he started harassing me to sell him my truck. And I told him it was not for sale. He went to my son to sell the truck to my son, and my son came and told me. However, I said to him, when I went up there, I said to him, look, just put the parts back because you're not working on my truck. Just put the parts back in my truck. And in 2 weeks, when I come back from out of town, because I drive trucks over the road, I'll pick up my truck. He got upset and called Tara, the wrecking company, to tow my truck.
Okay. Are you in possession? Are you in possession of your truck currently?
No, the wrecking company still has it.
Okay. But they're not here. And it looks like court notice was sent out on the same day that you filed an answer.
It was not abandoned. They took it. He called them to come and take it. He did not
I mean, the term of abandoned motor vehicle is a general term. And you'll have situations where auto repair companies, if they're in a dispute with someone, they'll call the tow truck company to come and get the car.
Okay.
And take it away. And then the tow truck company starts proceedings under the abandoned motor vehicle statute to get ownership of the vehicle. So based upon what you told me, sir, you may want to send notice to Tar Rucker about the vehicle and that you're seeking to
The
recover the
issue,
vehicle?
well, the issue with Tara is that they sent an exorbitant bill, somewhere in the region of $8,000. So my dispute is, one, when I told the guy before I went out of town, when I come back, I will pick up the truck. Just put my parts he took out of my truck. So when I came back, that's when he told me the wrecking company came and got it.
So just so you know, Mr. Cousins, you could be in a valid dispute with the owner of the auto repair shop.
Gotcha.
And they can call the tow truck company to come tow the truck away. And because of the way the statute is written, the tow truck company can become the rightful owner of the vehicle if you're not taking steps to protect yourself along the way. So it's not we're just going to be arguing over the phone and that kind of stuff. You're going to have to take steps lawfully to notify everybody of your claim to have a rightful ownership to the vehicle, and that the dispute is based upon something that is going on with the auto repair company. And they know or should have known that they couldn't just call somebody to tow the vehicle away.
Yes. Understood.
So you got to put everybody on notice so that this matter can get resolved.
I understand, Your Honor.
So I'm going to dismiss this claim for warrant of prosecution because Tara Recker is not here. But you do need.
All right, I will reach out to them and go from there, Your Honor.
Yes, sir. Is there anything else, Mr. Cousins?
No, I thank you, Your Honor.
Okay. So let's see, Mr. Gardner.
Yes, sir, Judge.
Were you able to reach an agreement?
No, Judge, I think we may be able to talk more, but I was not able to resolve it based on the authority I have today. So for today, we would just ask that the court enter the judgment against Omni since they have not filed an answer themselves.
Okay. So, Ms. Hamilton, Mr. Gardner has the right to make that request and have that request honored based upon the current state of the law.
So I'm sorry, Your Honor.
I was going to say if Omni Day, if they're seeking to challenge this, they can make whatever lawful claims that they can make.
I would like to speak to them.
Are you open to her joining my sister, the owner of Omni Day Spa, coming to the Zoom? I'm communicating with her via text. She's going to leave a client to come to join the Zoom and speak for herself in her spa.
I think the only problem I would have, Judge, is we don't have that notarized answer in writing, which I think may be key here.
And I was just going to speak to that fact. Your sister can come and she can say whatever she wants to say. But if she has not filed anything, she's not in a position to lawfully make any kind of argument.
Okay.
And so, and that's what I say. It's like, I can be as sympathetic as possible, but I have to follow the law.
Yes, I understand.
So if that means the saint loses and the devil wins, that's the way it's structured. Not calling you the devil, Mr. Gardner. But
I understand, Judge, no problem.
Yeah, but it's my job is to issue a judgment with neither fear nor favor. And so if Omni Day Spa received notice and they didn't respond, that's Omni Day Spa's problem.
And I'm happy to speak to them too, Judge, and try to work this whole thing out to where.
Yeah, that's what I thought. When we were in the breakout room, Mr. Gardner, I thought that's what you said, that you would be happy.
I'm
to
willing to
speak
do
with them.
that, but it has to be something my client's willing to accept, not just what you can offer. And I'm still happy to talk about that.
So when are you happy to speak about it? Yeah,
Miss Hamilton, what Mr. Gardner is basically saying is that as the lawyer, he has to check with his client as to what they're willing to do. He can't bind his client to an agreement without their approval. And generally, lawyers come into these situations and the client has told them what they're comfortable with.
Correct, Judge.
And if what you're asking for is something outside of what the client is comfortable with, he has to get approval from the client, because if he approves and the client says, this is not what I wanted, Mr. Gardner will be on the hook as far as the client saying, I hired you to resolve this matter and you didn't resolve it in the way that I wanted you to do it. So lawyers take, we call it punching your ticket. Lawyers take seriously the fact that if I go outside of certain parameters, I can get my ticket punched, meaning I can get sued, get a judgment against me, or it can go to the state bar and I could lose my right to practice law.
I definitely don't want that to be any issues for Mr. Gardner. And
like I told Ms. Hamilton that as you said, Judge, and in fact, I'm sure she heard that you used the exact same terminology I did, that I had certain parameters I could work with today. What she was offering was outside of those parameters. I'm not saying we won't still discuss that, but as far as today goes, I need to get back to the client and see what they are willing to do, which I've done as we were sitting there, as I told her I would do. So I'm happy to talk about it further, but.
So there were two things that we discussed, which I wasn't feeling comfortable speaking on behalf of Omni-Day's Law. And why they didn't answer, things like that. That's one thing. And just, as you said, Judge, Your Honor, before we moved over into the breakout room, it is a matter of the monies that is owed. I am willing and capable within my budget. It will be stretching my budget. And I did let Mr. Gardner know that I can start paying $600 every 2 weeks. Starting on the 25th of February until this is paid off at the agreed amount of $7,500 plus a $225, I believe $225.50, which are new fees, HOA fees that come out quarterly. I'm willing, to start there to pay this. It appears as though there is some communication that went from December to now that has been missed. Like, I've been making payments. I made a total of 3,000 payments from December, from the end of the last quarter of last year. And now my agreement or my proposal to pay $600 every 2 weeks to get this satisfied, Mr. Gardner will have to go back to his clients
and just so you know, Ms. Hamilton, that Mr. Gardner is on the same obligation as it relates to collecting debts. Like, he can't show up your house with a 357 Magnum handgun and say, give me the money, or somebody is sleeping with the fishes. He has to follow the law just like anybody else. And debt collection is one of those things where it gets to be expansive, because if a person is not paying off a debt, it could be very frustrating to someone who is owed the debt. So we don't take those steps of being overly gracious. Well, I'm sorry, you owe the debt, but you're not working, or the debt was owed. They've identified Omni-Day Spa as a potential garnishee that can resolve the debt. And if the garnishee if they don't respond, they can be on the hook for the whole thing. And I know you're saying like, this is your sister, but if this was, Joe's Crab Shack and they didn't respond, they would be on the hook for the whole amount. And they would have to come to you to try to satisfy that. But that cuts the plaintiff out. They've been satisfied. They've been made whole. And now the dispute is between you and Joe's Crab Shack.
Yeah, I'm sorry.
No, as to whether the money, they can recover the money from you through garnishing your paycheck. I mean, and they would go through the same process. So,
well, and Your Honor, I wish that we had in my communications with them back, I believe it was in November, advising that I don't even know why Omni Day Spa was brought into this in the first place, and that they should have never, been communicated. No one said anything about, why, how do we go from there? I started making payments even in that communication. So, I mean,
all Omni Day Spa had to do was file an answer saying that you're not an employee of their company. You come to court, they come to court, they show that this person has never been an employee of the company. Mr. Gardner would then move to dismiss this current action, and he probably refile with something else. Because I don't know, has it, in this case, Mr. Gardner, did you ever get to the point of asking the statutory questions as it relates to collection on a debt?
No, Judge, I don't believe so.
So these things can be simplified by just simply responding.
Okay.
And I'm going to issue the order.
Does she have an opportunity, she's here, does she have an opportunity to answer in writing, or I'm from which it sounds as though we weren't able to answer on this hearing today. She's not able to provide an answer.
So I can't be in a position of giving legal advice. The thing that I could do is suggest that she consult with a lawyer. If this is an amount that is truly owed, it is in Mr. Gardner's client's position, or interest in Mr. Gardner's interest to enter into some kind of binding agreement to have this debt resolved. It's in nobody's interest to keep coming back and forth to court, arguing over something that everybody agrees is owed.
Right.
So,
I definitely agree. And Mr. Gardner, I don't want my sister to have any issues with her new spa. She has nothing to do with any of this. I wish that she and I knew better to answer this, but she didn't. Hindsight. So if you mentioned the 236250, I don't have it, but I will find it just so I don't want her to have any issues. But you're asking that I pay 236250 by the 21st. If I can pay that, what will you agree to do so that she does not have to deal with this anymore? I don't want her to have any issues. That means that she would have to contact her attorney, pay
if you can,
her attorney to answer, and I don't want that.
If you will do that, and the court is willing to continue this case for 2 weeks to receive the payment, then we could dismiss the default at that time, the request for a default, if Judge Gardner's okay with that. It's a little unusual in this type of case, but I think we could do that.
I'm fine with doing whatever gets to a resolution of the matter. Next week, I'm going to be doing first appearance. So that means that Tuesday, I will be free. I know.
Tuesday, the 22nd.
Yes. And I actually have a judges conference to go to on the 24th, 25th, 26th, 27th. So I'm going to be out of the office on those days. If you can meet those obligations, Ms. Hamilton, I will still ask Mr. Gardner to send an order, and
Sure.
I'll just put a post-it note on the order that I won't sign it until the 23rd of next week.
Okay.
So essentially, we're still at the same place, all right? So you have to still, Mr. Gardner, you still have to, even my proposed $600 every 2 weeks, starting on the 25th, you have to go back to them for that.
Well, so here's the thing. We never got that far because originally, Judge Gardner, the discussion we had was Ms. Hamilton, you indicated you could not do the 23,260.
I couldn't.
And so at that point is when I said, all right, well, if we can't do that, there's nothing further to discuss. So once that's received, that still leaves the balance on the judgment, which we would then have to decide how to resolve on that, right? So that's the other piece of this we'd still have to work out.
Because what I'm trying to do, Ms. Hamilton, is I'm trying to be as malleable as I can. I understand your concern as it relates to your sister, and I'm happy to postpone entering a judgment to just make that happen. But at the same time, it's in default status. Mr. Gardner's client is entitled to receive payment or receive an order saying that payment is due. But I'm willing to do what I can to help both sides as long as both sides are in agreement, as this is something that might lead to a resolution. But if there's no resolution, I'm going to sign the order, and then Mr. Gardner's client is going to, or Mr. Gardner is going to take the steps that they need to do to enforce judgment.
Which would include continuing to speak with you, if you're still willing to discuss and trying to figure it out. So that doesn't mean this necessarily ends the discussion on how to resolve it. Ultimately, it's in everybody's interest to try to resolve it without having to do everything or to collect a judgment.
Okay.
So I've emailed my office. They have your contact information. They're going to reach out on the original thing you mentioned, the $600 a week. You can follow up by the close of business today.
Every 2 weeks.
Every 2 weeks, I'm sorry. And you can follow up with our office on that. And then we just talk, as long as we stay in contact. If they come to a point where they cannot accept it, they'll do the same thing I did. They'll say, look, we can't do that, right? And let you know that if we can't do it, we cannot.
Okay.
And so this is where the whole term of you can't get blood from a turnip comes from, is people who are generally in Mr. Gardner's position, they know that having a negotiated agreement that is going to be honored is better than chasing people down to try to get payment. So just remain in contact with Mr. Gardner. Be honest about what you can do as it relates to payment, because the one thing that you need to understand is whatever you agree to, make sure it's something that you can honor, so that we don't have to be at this position again.
Yeah, I thought that's what I was doing, but here we are. Yeah.
No, I mean, it's like I said before, it's I see it every day as a judge, where people come into court And some people overvalue their case and some people undervalue their case. And it's not until they are placed before a third party who is like, okay, well, I'm going to do what the law requires, that people start softening up on whatever position that they may have. But I'm certain that this will get resolved.
It will.
Mr. Gardner has appeared before me several times, and you seem to be a pleasant person. So cooler heads win the battle.
Thank you, Judge. And Ms. Hamilton, we will definitely be in touch, and feel free to contact my office as well.
Okay.
And that is my only matter before you today. Would you like me to send an order over, and may I be excused?
Yes, sir. You can send the order over. I've made a notation that I'm not going to sign it until the 23rd. If there's been an agreement reached, please let me know, and I'll tear up the order.
And Judge, since Shaquana Hamilton, the owner of Omni-Day Spa, is here, is there anything that she needs to, she does need to answer, or is that the judgment that you're stating that you're going to sign on?
Right. That's the judgment that I'm going to sign on the 23rd. Okay. And just so she understands, the judgment will be against the spa, and saying that Mr. Gardner's client is lawfully authorized to pursue collection matters against the spa.
Okay.
Okay. Ms. Hamilton, Mr. Gardner, you both can be excused. Thank you for your time.
Thank you very much.
And
Judge.
Ms. Shaquana, you can be excused also. Miss Mary, did we get an answer on the Edwards versus King Automotive?
Muted.
Did you see that the costs have been paid into the court to open the default?
No, sir. The only thing they did was file a late answer.
Okay, that's what I saw in the file also. Ms.
So when
King.
you say, I'm sorry, when you say something that was paid in, because I filed a few judgments against some of my other customers for abandoned vehicles and things of that such. So when you saying paid in, what are you referring to? Because I have a receipt that I paid something. So I'm just trying to.
So you essentially, what did you pay?
So for so I filed for other customers. I filed 2 files.
I'm talking about this case. I don't care about cousin, mama, anybody else. This case.
On this case, it just says I filed, and it just says late. It doesn't show anything that was actually paid in on this particular one.
So when you file late, you have to pay the cost of the litigation to reopen the case. And so when I looked in the system, all I saw was that there is a late answer filed on December 22nd, 2021, that there was a motion filed on October 20th for a request for a default, and the action was filed on August 11th.
Yes, I see the August 11th, and then my file was on the 22nd. And yeah, that's the only thing I have.
So what that means is that you're in default status, and I'm here to determine how much you have to pay, or King Automotive has to pay to Miss Edwards. I'm not here to determine whether there's any liability, because that was lost when there was no answer filed in a timely manner.
Okay.
So what I'm going to do is ask both of you to raise your right hand for me, please. Do you affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay. Ms. Edwards, you are the person that is proceeding to have a default judgment entered. Can you tell the court how much you believe is owed?
I believe that's owed $6,123.
$6,123. How did you come up with that figure?
That figure is from the cost of the engine because I lost the warranty on the engine. So even if I pick up the car and the engine was not replaced, if it does not work, whatever's going on, I cannot recover that money. I can't get another engine. I have to pay for another engine out of my pocket. During this time, I have had to pay for rental cars. I've had to pay lifts. I've had to borrow cars. And the entire time, it doesn't take an entire year to replace an engine.
How much was the estimate for the repair of this vehicle?
The estimate for replacing the engine was, I believe, $1,100. They called me and said there was an issue with the water cooler. I mean, with the water pump. I found out several months later that they had not replaced the engine, that they had replaced the water pump, but they had not replaced the engine, even though the original request was to replace the engine. When I went to pick, I just said, when I went to pick up the car because it wasn't being repaired, I asked that, I was just going to pay the cost. Whatever it was, I was going to pay it. I was going to pick up the car.
Miss
I'm
Edwards.
sorry.
Fewer words.
Okay.
How much was the contracted, negotiated price for repairing your car?
I believe it was $1,120.
Okay, $1,120. How do you get to $6,000?
The cost of the engine, the cost of rental cars.
Did you pay that?
I purchased the engine separately.
Okay,
From a
and how
different
much?
company.
Hold on. How much did you purchase the engine for?
The cost of the engine was $1,300.
Okay. So we're gonna treat this as if you're.
No, I'm sorry. The cost of the engine was $1,274.40.
$1,270.40.
$1,274.40.
Okay, so I want you to keep in your mind that this is like we're at a grocery store and you're scanning items. So the grocery store doesn't just come and say, all right, $500. And you say, well, how do you get to that point? You got a receipt. We're going to add it up. Okay. So we have $1,120, $1,274.40. What's next?
The cost of rental cars is $1,176.90. $1,176.90.
90 cents. I tell you, I think quick, but my ears are slow. So you got to make sure that I can get the information in my head. Now, how long was this rental period?
I've had to rent cars off and on since March. However, I didn't start the cost of the rental car until June.
How long was it supposed to take for the car to get repaired?
I thought that it would only take about 30 days.
No thought.
They did not. Okay, so they didn't give me a time frame. I asked for the time frame when I dropped the car off. She said she didn't know. The person at the front desk said she didn't know, that they would let me know. After that, even after they told me they had replaced the engine, 30 days later, I found out they had not replaced the engine. So
And
they
how
did
did
not
you,
give me
how
a
did
time
you
frame
make that determination?
that they hadn't replaced the engine.
Yes, ma'am.
The place that had the engine and called me and asked me if it was okay to release the engine to King Automotive. But this was 30 days after they had already told me they replaced the engine.
Okay. How did you come to choose King Automotive as your destination for getting your car repaired?
I contacted a mechanic that was a mobile mechanic because my car was at my house and it would not crank up. I contacted a mobile mechanic. He said that he does not replace engines. And he referred me to King Automotive.
What is the vehicle in question that we're discussing?
It's a 2012 Dodge Grand Caravan.
Okay. So it still gets us about $3,000 and some change.
The rest of the cost was for the repair of the damage of the door and the side panel of the car. So I got a repair estimate. They gave me Maaco gave me a repair estimate. They said it's just kind of rough estimate since they didn't actually have the car to determine. They gave me the repair estimate of $2,177.03.
And you said 2 cents?
3 cents.
3 cents. How were they able to give you an estimate and the car
I
wasn't
showed
in their
them
possession?
pictures. I showed them pictures of the car, of the damage of the car. So this is not an estimate for the engine replacement. This is the estimate for the damage that was done to the back sliding door and the back of the car.
Okay. And that repair work has not been done on the car.
When I talked to King in December, he said that he had just repaired the car. As I said, I don't know. I haven't seen the car since May. So I don't know if the engine was actually replaced. I don't know if the damage has been fixed because like I said, after they told me they had replaced the engine, 30 days later, I found out they had not replaced the engine. They were telling me that they just needed to do some tune-ups and test the car to see if it was running.
So I need you to be a little bit more precise with your language. When you say they
King
who?
Automotive. King Automotive.
No.
Okay, I'm sorry. Go ahead.
Because you switch between I spoke to Mr. King and then they. So I'm trying to hear what came out of Mr. King's mouth.
December, I spoke with King. I called King Automotive's repair shop and King answered the phone. So I spoke with King Taylor, the owner of the shop. And he said that he had repaired the door. He also increased the price again from the first increase. And I said, it sounds like that you're trying to make me pay for the door repair still. He said, no, he was not trying to do that, that the extra cost was for programming the engine and for replacing the water pump. However, the water pump, as I said, was replaced before the engine was replaced.
Did you request a new estimate?
I did not request a new estimate because the estimate that I requested was for the engine to be replaced. I asked for the engine to be replaced. That is all that I asked to have done.
So the evidence that you have is you called the shop and you spoke to a person that represented himself as King Taylor, and this person gave you this information.
Yes, that's correct. In December, the person represented himself as King Taylor. He gave me a cost of around $2,000, which was an increase from the first cost increase.
Have you ever requested to come down and view the vehicle?
In May, I went to pick up the vehicle. That's when I saw it was damaged. When I went again to just pay the cost, that's when they added $500 to the cost and refused to give me the insurance information. Since then, I have not, that was in June. Since then, I have not requested to see the vehicle again.
Why
Because
not?
every time I call, he's not there. It's every time I call, it's a runaround.
Have you paid any monies to King Automotive?
When I dropped the car off, I paid $230 for the diagnostic because they told me that I had to pay for that. Even though I was asking for the engine to be replaced, I had to pay that for them to tell me the engine needed to be replaced, I guess.
When you dropped the car off, was it by a tow truck or did you drive it?
I dropped the car off by tow truck. The car was picked up from my home and towed to King Automotives. And before I dropped it off, I called King Automotives 3 times and told them the car was not running. I had already purchased an engine. I was asking to have the engine replaced. When I came in with the vehicle, I said again that I had already purchased an engine and that I wanted the engine to be replaced.
Were you told to purchase the engine?
You said, was I told to purchase an engine?
Yes, ma'am.
Well, I would not by King Automotive Repair. I was not told to purchase an engine by them. I had went to and spoke with another mechanic. He told me to purchase an engine. That's how I wound up purchasing an engine.
Why didn't you take your car to that mechanic for it to be repaired?
That mechanic was telling me that I would bring the car to him and then he would replace the engine and let me know if anything else needed to be replaced. But he was not going to provide the parts. So I would have to go and get the parts and then bring them to him. And then he would put the parts on. And then if he needed anything else, he would tell me and I would come and I didn't feel comfortable with that. So that's why I did not allow him to repair the car.
How is that different from the arrangement that you
With King
have
Automotive,
described with King Automotive?
they were supposed to just replace the engine. I specifically asked them because of the experience of the other mechanic, if some other parts are needed, am I going to have to bring you parts? Am I going to have to bring you oil, gaskets, anything else? They said no, they were going to replace the engine. And then if there were any additional costs from replacing the engine, they would let me know. But then it turned into something completely different.
And that was in March, you said?
March of 2021, I dropped the car off. And then in May, after they still had not replaced the engine, I went to pick it up. That's when I saw the damage. In June, I went to pay just to pick the car up and argue about the damage, already having the car. I went in, I attempted to pay. When I asked for the insurance information, there were 2 ladies at the front counter. I asked for the insurance information. She said, hold on a minute. They walked outside on the phone, made a phone call. She came back in and she said that it was $500 more than the original cost. And they did not have insurance. They didn't know what I was talking about. I needed to file a claim with my insurance company, even though the damage was done while they had the car.
Is there a reason you didn't take that route?
Because I didn't feel that it was fair or legal for them to suddenly change a price that they had already quoted me. That before I asked about the insurance information, they were going to check me out at one price. And then I asked about the insurance information and the office manager locks the system and goes outside and makes a phone call and comes back in and adds $500 to the total. That doesn't seem legal to me. I don't know whether it is or not, but I did not agree with that. So I wanted to speak with the owner. They said the owner would contact me. He did not contact me. I called repeatedly, still no contact.
Okay. Is there anything else, ma'am?
I just, like I said, I've tried to resolve this issue. I don't know what else to do to resolve this issue. And when I spoke to him in December, the price had gone up from that original $500 being added to the cost to $2,000 and something. And it just doesn't, I don't know. I don't know. I don't have anything else. No.
Okay. Did you receive any kind of estimate as it relates to the cost going up additional $500?
I have not received anything. When I talked to him in December, he said that the water pump price was written in a different color ink than the original quote, but I have not received any documents or anything else from King Automotive.
Did you ask for a final tally of everything that is owed before you left?
In June, I did not ask for.
No, when you had this discussion about the additional $500.
This discussion so there's the additional $500 that was in June. I did not ask for the final tally. I handed them my letter. I gave them my letter of complaint, and I gave them the demand letter asking for the car. And they told me that King would call me.
Okay. Ma'am, with King Automotive, just for the record, can you identify yourself?
Sure, my name is Sarah Elliott.
And how are you related to King Automotive?
I'm the office manager.
Were you in any of these discussions with Ms. Edwards?
I have been, yes, sir.
You've heard her listing out the amounts of monies that she believes that she's owed.
Yes, sir.
Assuming that she is correct, because we're not here to litigate whether she's wrong. You do have a right to speak about damages that you believe may be owed. And it doesn't mean that you agree with it, but you have a right to say that. Can you tell me?
So basically you want to know about the damages to her vehicle, or what is it that you want?
When I say damages, is what she may be owed throughout this whole matter.
Well,
give me a final number and then break it down.
Okay. I honestly don't have a number from King. We just have a balance due to King Automotive that is nowhere near the $2,000, which she claims that she was requested in the shop. But as far as what is owed to her, we never promised to pay for any rental fees or anything like that, or provide any rental car for her. Her engine was purchased outside of the shop. We are unable to warranty anytime someone brings a motor in. And the time that we give for estimate time for repair is always an estimate. And that is something that I reiterate to my customers. It's the estimate time of completion. So that is, something that the customer would have to come up with as far as finding rental or, means of transportation while the vehicle is being repaired here at the shop. But as far as what we should pay her, we did repair her vehicle, the damages to her vehicle. We did reach out to Republic Service. The vehicle was not inside our shop, which we would be held accountable for if the damage, of course, was inside the shop. But the vehicle was outside of the shop, and we're not necessarily responsible for that, but we did fix the door to her vehicle. So we're not asking her to pay for that. We didn't increase her bill based on that. So again, she just only has a balance due to us of just what we did, what our initial agreement was, and that was to install the engine. She also had a reprogramming of a PCM.
So what is the normal time, just speaking in generalities?
Honestly, I wish I could.
Hold on, ma'am. Let me ask the question before you answer it, okay? How long is the time that you would estimate in your knowledge, skill, and training that it would take to replace an engine?
Once a vehicle is pulled in to the bay, estimate time of completion could be between 3 to 5 days. once it is actually pulled in on the lift and my tech has his hands on it. That's 3 to 5, between 3 to 5 days. It could be up to 2 weeks if we run into any issues.
And believe me, I'm trying to get repairs made to my vehicle. And I'm doing everything I can to cut down that window that you're talking about. Because once I turn my car over, it's not going to be there for 30 days.
Right.
You're going
And
to
that's
order
another
the parts.
thing.
Hold on. Order the parts, get the car repaired, and you're going to give me an estimate of how long that's going to take. Because we don't have good public transportation in this city. So when you take a person's car, you're really potentially taking their livelihood, because everybody has to drive to get to places.
Right.
So I'm sensitive to that. And I'm not a person that plays games with that. If you're operating a business, your business should run like a business.
Absolutely.
And so I'm
When the
thinking
vehicle initially came in, we did tell her estimate time. But again, with us not having the space to pull it in right away, that became an issue because one of the other vehicles was disabled on the rack for quite some time. I honestly have vehicles here that I've needed a motor here for 6 months. And that's because it's a reman motor. We're waiting on parts, distribution, you know, it happens. So again, I always have to step in and say, hey, anything that we give you is estimate time of completion. And that's not really understood. You know, warehouses are low on, you know, remanufacturing parts to us and delivery and things like that. So
I understand. Let me ask you a question, ma'am. Do you have any children?
I do.
What if you take your child to the daycare? The daycare says, well, that's going to be 6 months before you get to see your child again. Because, you know, stuff happens and we're just, you know, we're going to feed the child. We're going to take care of the child, but you're not going to see your child for 6 months. Would you deem that to be reasonable?
I don't think that's a good way of.
Well, I'm saying with the car, most people don't have 5, 6 cars laying around where they just, this is my
I guess
Monday
I wouldn't
car.
use that analogy, a car
And
and
this
a
is my
child.
Tuesday car.
Right.
Your car helps you get to where you need to go.
Yeah.
And you can't operate without having a vehicle.
Absolutely.
Most parents, you're putting money out for your child. That child ain't bringing in no checks. Just like a car ain't bringing in no checks.
Right.
You got to pay for gas. You got to pay to get the car washed. You got to pay to get the car repaired. You're just putting out money, but you still want to see your car.
Now, if I might add, she did bring her vehicle in saying what a vehicle needed. We always recommend diagnostic. The vehicle apparently had been disabled for some time. The engine was at another repair shop prior to it coming to us. So it looks like there's been other hands touching on the vehicle, and that's, you know, I mean, and that, with that being said, that engine, when it came in, I don't know if she had even looked at the engine and saw the integrity of the engine, but we, you know, did what we could to install it. Later, she needed a fuel pump. I know she mentioned water pump, but she actually needed a fuel pump in adjacent to that engine. That fuel pump that was on her vehicle was damaged. So we replaced the fuel pump at no cost, just labor. I mean, there was other things that were needed on this vehicle, I guess, that may have been assessed by someone else as far as diagnostic goes. I mean, if we just come in and you say, hey, I need a tire, but in actuality, you need a whole hub assembly. Are we going to just do a tire and let you walk out of here with a hub assembly, not without replacing what you actually need, and you go down the street and your car breaks down? Who are you going to call? You're going to come back to us because you asked us to do the work. So if in actuality you needed diagnostic, which we informed her that she did need diagnostic, and then that's when she okayed the diagnostic, which was a 2-hour diag, and then that's when we found out a fuel pump was necessary.
And I did hear that testimony, and I did take that into account, that it appears that Miss Edwards may have been going around asking different people what they thought, which is something, Miss Edwards, I'm gonna hold against you. Because if you're choosing to take your car to this location, you need to have clear conversation about what it is that you expect. You don't have to hold your hand up, ma'am. I'm gonna let you speak. Ma'am, I'm not done speaking.
Okay,
But I'm
that's fine.
just
I didn't want to
saying.
cut you off. I didn't want to cut you
Yeah,
off.
I'm just saying, you don't have to hold your hand up. I'm gonna let you speak. But you need to have a clear understanding of what work is requested, the time amount, and the estimate. And I understand that estimates change. There may be, you get in there and you say, well, hey, this is, we saw something else that you may need to get repaired. If you want us to do it, it's going to cost you this amount of money. If you don't want us to do it, that's fine. But we're just giving you that service because you have entrusted us to work on your car. So what were you going to say, Ms. Edwards?
I was going to say that the fuel pump, I apologize, the water pump, the fuel pump was replaced before the engine was replaced. And the other, as far as the warranty on the engine, the warranty was issued by the company that I bought the engine from.
Right.
I wasn't expecting a warranty to be issued by the repair shop. The warranty was issued by the seller of the engine. I did not take my car as far as having a different diagnostic to a different company. So another repair shop was doing something with the internal parts. The previous mechanic that had the engine, he did not do a diagnostic on the engine. He was just going over information, which is why I did not allow him to replace the engine. I called King Automotive 3 times before I bought the car. We had a long conversation when I left the car. I thought that we were clear on what I would like to have done. Like I said, she said the diagnostic was mandatory. Okay, I got the diagnostic. Okay, you do need to have your engine replaced. Okay, they were supposed to be replacing the engine. That was the entire conversation. That was what was supposed to happen. The fuel pump was replaced before the engine was replaced, even though I requested to have the engine replaced. So that's all I wanted to say with that. That's all I wanted to say with that.
Okay. What was the reason for the engine to be replaced?
The car would not crank up. So so sometimes it would crank up, sometimes it wouldn't. So I would like turn it over and it would try to turn over like 6 or 7 times before it would actually crank up. The day that I was going to have it towed, I actually cranked it up and drove it onto the back of the truck. I just wanted to have it. It seemed like it was like had a dead battery, but I know it wasn't the battery because the battery was brand new. So that's why I wanted to have the engine replaced.
So, and that's the thing that I'm trying to get into, because I heard this whole thing of the engine needed to be replaced, but it sounded like this third mechanic that you spoke to convinced you that the engine needed to be replaced.
Yes.
So
go ahead.
I was going to say, so did you bring your car into King Automotive saying my engine needs to be replaced, or did you bring it in for a diagnostic and King Auto said, hey, the engine's going to have to get replaced?
So I brought it in saying, when I called, I asked, how much would you charge to replace my engine? So when I brought it in, it was under the understanding that I wanted to have the engine replaced. The diagnostic was just something that was required, but I did ask them to replace the engine.
So what if the true damage may have been just a $600 repair?
I had already bought the engine. Like I was already out of the money for the engine, so I wanted it put in the car. And I do understand what you're saying, that a diagnostic would have resolved, it could have been a cheaper repair. I do understand that, but I had already bought the engine and it's like 300 pounds. So I would have to pay somebody to take it back to the seller.
Right. And that's the reason I use the child in the daycare analogy. I don't go into when my kids are in daycare, I don't go in there telling them, you need to teach my child this way. You need to teach my child that way. I make those determinations up front as to whether I want my child to be here. And I trust these people to take care of my child. And if they're doing something that I don't agree with, I take my child out of the daycare. I'm not running a daycare. I'm a parent paying money for a service that they're providing. You're a person that took your car there, and it sounds like to me that you were more involved in telling them what to do to fix the car than just letting them tell you, this is what's wrong with the car, this is what the cost is going to be to fix the car. So if you take those steps, you may incur more of an expense.
I was, and that was my mistake. And when I realized they weren't doing what was even originally agreed upon, I went to pick the vehicle up. That's when I saw that it was damaged. So that's kind of the damage, even though now looking back on it, I should have just picked it up even with the damage and argued with them about the damage later, but I didn't. That was my
Your
mistake.
vehicle was here for engine replacement, and we did in fact replace the engine.
And
engine has been replaced.
There's certain you had pictures of your car before it went in and pictures of your car when it was ready to be picked up. So you can go back later and say, hey, these are the photographs. This is evidence that I have that this car was damaged here, and just deal with that issue. But it compiling everything down into, I want it to be done the way that I want it to be done, sometimes doesn't give you the reaction that you want.
That was my mistake. I didn't take the vehicle because the tow truck driver actually recommended that I leave it there because they were not there. They had just left it outside with the keys in it, maybe thinking that I don't know why it was left like that. So I won't make any assumptions. But whenever I went into the office, whenever they finally did show up and I went into the office to talk to them about it, okay, we're going to file an insurance claim. That did not happen either. Or maybe they filed an insurance claim and the insurance claim was denied by the garbage company. So they did not want to file an insurance claim on their insurance and wanted me to file it on my insurance. So that's kind of where that back and forth started with the damages.
Okay, and I didn't see a counterclaim being filed in this case. The answer was filed late. Are you in possession of the car, Miss Edwards?
I am not. They still have the car. That's all I'm saying. Like, I don't know what has been done or what hasn't been done. Even if I am able to pick it up, I'm going to have to take it to another mechanic to see what actually, if the work that they promised since March of last year has actually been done.
Yeah, when the vehicle came in, it did not drive. The vehicle is ready to be driven off the lot, does not need a tow truck to be picked up. It is operating and it's ready to leave.
The $2,177.03, was that for the rental car?
It was for the damage.
And that was the estimate that you were given, but
from them from Mako looking at pictures of the car.
Okay. So I'm going to treat that as a separate claim. The $1,176.90, that was for the rental car?
Yes.
Okay. I'm ready to enter a judgment. And what I'm going to do is I'm going to give you, Ms. Edwards, a judgment in the amount of $1,120. plus the $1,274.40. So let's add that up.
Okay, so being that we have fixed the door, the damages, we're paying for the damages?
If the car was damaged in your lot, you have a duty of care.
Yes, and like I said, well, it was not taken into our facility yet. So we are on a public lot that are owned by other businesses. And we do have signage in our office saying that we're not responsible for any damages occurred on the lot. However, we did, under our grace, fix and repair her door to her vehicle.
I would think you would be responsible for that, regardless of what sign you have setting up.
And that's,
and
again, under the
not
grace, on the
responsible.
good graces, we repaired it. So are we still paying for double repairs, or, because we repaired the vehicle?
So my understanding is that the $2,177.03 was the estimate as it relates to the repairing of the door. That there was original amount of $1,120 that was listed as this is what we're going to charge for the repair of the car. My understanding is $1,274.40 is for the engine. Is that correct?
Yes, that's correct.
Okay.
So I'm given a judgment, even though I believe her statement was, it was $200 or something that she paid for the diagnostic. And when she originally dropped the car off, and there is an estimate given of $1,120. I'm taking into account that this car was dropped off in March of 2021. And I just believe in a business such as yours, you just don't have the right to just hold on to somebody's vehicle.
Well, we didn't hold on to it because she had her dates slightly off, because I have here, anytime we speak to a customer, we do notate. I mean, the vehicle was dropped off on the 24th of March. When she called on the 30th of April, when she was called on the 15th of April, she spoke with Jasmine, and I'm sorry, Nara, and was given wrong information about her vehicle being ready. That vehicle was not ready. It took us a little minute to get the motor put down here because it was at a shop a little bit, not in the same facility, basically. So when the engine was brought down to us, because that other business was not open, he didn't allow us to just pick it up the times that we went there. So when he finally gave us the okay to pick it up, because he was trying to reach her, the owner wasn't there. It was just a whole misunderstanding. When we finally got the motor here is when we can actually liably and legally say, okay, now this is our time to actually pull this vehicle in and work on it. We are not able to pull in the vehicle without the engine here and just have it holding and waiting. So I think that time frame is definitely should be taken in account. On the 3rd of May is when she came in. The vehicle was ready for pickup. It was ready 2 days prior to that. She came in.
The engine had not been replaced in May.
Hold on, Ms. Edwards. Hold on. I can only listen to one person at a time. I'm going to let you speak. Continue, ma'am.
Okay, so yes, that motor was replaced in May when she came to pick it up. That's when her and I both, it was raining that day, her and I both noticed the damage on the vehicle. And I was surprised, as she was, where it was parked at. It was parked next to where our garbage truck is. Again, I immediately got on the phone with Republica Trash Services, sent them pictures of her vehicle. I have copies of that email that was sent to them, pictures of her vehicle. They asked for footage. King at the time was not available to provide footage for me, but it is a timeout situation where we did not have footage for that time frame. So I was not able to provide that to Republica. I told King, I said, we got to do something, figure this out. You know, he went back and forth with me and saying, hey, well, you know, we're not responsible. I took it under my care to say, hey, we're repairing Miss Edwards' vehicle. So again, we came to agreement. Let's repair her vehicle. Let's get it back to her. At this point, we don't have the space for any other vehicles. I can't take anymore. I can't have any more sitting on my lot. So we repaired it. We asked her to come back in to pick up the vehicle. June 17th is when she came to, I guess, just pay and pick up, not realizing that her doors and everything were, I think we didn't repair the doors until August. No, I'm sorry, June 17th. The doors were repaired. June 17th, let me just make sure. The doors and everything were repaired. We have repair status ready for pickup. And she, I guess, decided not to pick up that day. She had a tow truck here, and I'm not sure, I was not here that day, so I'm not sure what the outcome as to why she didn't pick up. December is when she spoke with King to just come to I guess, oh, I'm sorry, she did not pick up because she wanted reimbursement. And she didn't feel like she needed to pay, which was just the balance of what we agreed originally on. There was no additional $2,000. There was no calling and adding $500. None of that occurred. I did step away to call Republica to find out what I needed to do. I stepped away to call King to find out what insurance company, what did we need to do. He said, in all honesty, she would need to file with her insurance company, and we can go from there. But we didn't even go that route. We fixed her vehicle repairs, and we went from there. We're not asking for her to pay anything additional other than what we originally asked. What she originally asked us to do was replace the motor. We did not charge her for the fuel pump. The vehicle's been here. Honestly, a counter cane would be storage, but we're not charging storage. She brought her own spark plugs, her own antifreeze, her own oil. We did everything she requested and asked for us to do.
And my judgment takes into account that, in my opinion, there are things done wrong on both sides. And so I'm trying to reach a judgment that speaks the truth about what I think happened in this circumstance. And so the total judgment is going to be for $2,394.40. I believe that King Automotive should have acted in a manner that gets this matter resolved. And as a judge, I have litigants before me every day that if I could, I'd cuss them up one side and down the other, but I know I can't. So I have to treat everyone the same. And Ms. Edwards, I think you made some missteps in maybe how you approached the matter. And you finally took the right approach of filing a civil lawsuit to recoup damages. So I'm giving you the damages that I believe that you are deserved. I'm not going to take the rental car into account, but if you purchased an engine for the engine to be repaired, and there is an amount that was expected to be paid by you, King Automotive is going to have to pay that amount to you. And hopefully in the future, there won't be cars sitting on the lot for 6 months, or cars that are placed in a way where they can be damaged. Because every owner, Ms. Edwards, has the duty to mitigate damages. And what that means, if someone comes through in the middle of the night and break out the window of your car, you can't just leave that window in that state and then later the person is caught and it rained a couple days while the window is open, and now you're saying that person needs to pay me for the damage that was done to my back seat. You do have a duty to try to mitigate your damages so that you can be repaid, but you can't just leave a situation out there and then later come back and claim that you should be paid for how much you were placed out. So that's what I'm trying to take into account.
I have a question. I just wanted to kind of make sure I had the numbers right. You said the cost of the engine, which was $1,274.40, and then the other amount was coming from where?
The amount that was originally negotiated, the $1,120 for the,
And that was never paid to us.
no, it was not paid. But I'm taking into account your actions and that you at some point may say, well, she needs to pay us that money. Well, if you file a lawsuit and you're successful in the amount that was paid, she has the money now to pay you.
Duly noted.
So I have a question about the car. Am I able to pick up the car, or do I need to go through some other process with King Automotive to be able to pick up the car?
It's your property, ma'am. You're able to pick it up. I would suggest that you call in advance, that you even get a tow truck to come take the vehicle off the lot, have somebody video and everything. So it's a smooth transition and you now have your property back.
Right, and I got my second question is, do I need to pay King Automotive anything in order to pick up this vehicle? In order for them to say, okay, here are your keys.
Well, right now, King Automotive owes you $2,394.40. If you come to pick up your vehicle and they refuse to return your vehicle to you, they may be in a situation of being possibly in criminal liability. They are free to pursue whatever claims that they may believe are open to them as it relates to this, and that'll get resolved on a different date. But as far as today, I'm making a decision based upon the amount of money that was owed, that I believe is owed based on the circumstances and the unique set of facts that I heard here today.
So King Automotive, can I ask you now, is there, when I come to pick up the vehicle, will there be any issues with me picking up the keys?
It has never has been, and it is not.
Okay, thank you.
Okay, is there anything else in this matter?
I don't have anything else, Your Honor.
Okay, so there's going to be a judgment entered, and on behalf of King Automotive, you have the right to try to appeal this judgment if you so desire, but I believe you would have to pay the entire amount of the judgment into the registry of the court in order to appeal the judgment as it relates to the damages.
Okay.
Okay.
Okay, I'm sorry, I do have one question. When we appeal, can we file a counterclaim then?
It will most likely have to be a new claim.
Okay.
Because you are only in a situation of appealing the money judgment that I issued.
Okay.
Is there anything else that is related to service and whether you believe that you're owed any monies? Those are things that have to be dealt with in a separate action that you would have to file.
Okay.
And you would have to file the appeal within 30 days of the judgment that's entered.
And we get a copy of this appeal, or we need to come down and pick it up?
Because Ms. Edwards is pro se, I'm most likely going to have to fill out the judgment form, and that'll be done either later today or tomorrow. And I'll give it to Miss Mary and she'll make sure that it's filed. And Miss Mary, the current procedure is they need to come down to the clerk's office to pick up a judgment. Is that correct?
Well, I think she's asking about the appeal, and she's going to have to file the appeal herself. We don't do that not from
Yes.
the judge's chambers. So
Yes.
once you write the order and sign it, then I will file it with the clerk's office. And I think the clerk's office will mail her a copy of it, but I'll have to double check that.
That's what I thought also, that they'll mail copies to both parties.
Yes,
But I didn't want to speak out of school.
that is correct.
Okay. Is there anything else from either party?
I don't have anything.
Okay. Can I leave you with one maybe piece of wisdom? There's a reason that lawyers make so much money, is that people choose to fight rather than resolve matters. And it just, lawyers, they just get happy when they see that coming and they start running the meter. This is a matter that it appears to be miscommunication, and then a failure to consider the viewpoint of the other person. And that's normally how disputes just keep lingering, because instead of people saying, well, maybe I'm not right, let me see it from the other person's side. They just say, I'm right, the other person's wrong. And sometimes, as I say, if you walk a mile in somebody else's shoes, you gain better perspective. I don't see anybody as being totally right. I don't see anybody as being totally wrong in this matter. But it definitely could have been handled better, I think, on both sides. So take that little grain of wisdom from this rapidly aging person. And I appreciate both your time and attention to this matter, and both of you are excused.